a tweet that you had in January 2024. The Supreme Court is a death panel. Is that your opinion?
In the context of this hearing, I think it is important to emphasize why I am here, which is to talk about my views on the First Amendment.
No. That's not what I ask you. Do you think the Supreme Court is a death panel?
Yes.
Do you look at Justices Sotomayor, Kagan, Jackson as members of the death panel?
I do not believe that the comments that you are referring to have relevance for this particular hearing, but here...
A witness called the Supreme Court a death panel. Then Senator Marsha Blackburn asked whether she meant the justices she disagreed with and turned the hearing toward allegations of government censorship against conservative news outlets. What followed put free speech and the First Amendment at the center of the fight.
Dr. Franks, we're here to talk about free speech, correct?
Yes.
And we're here to talk about that being a fundamental right guaranteed by the Constitution, correct?
Yes.
Okay. And the Supreme Court plays an essential role in guaranteeing those constitutional rights, correct?
Yes.
Okay. Now, I want to talk to you about a tweet that you had in January 2024. The Supreme Court is a death panel. Is that your opinion?
In the context of this hearing, I think it is important to emphasize why I am here, which is to talk about my views on the First Amendment.
No. That's not what I ask you.
In July 2025, the Justice Department filed a misconduct complaint against federal Judge James Boasberg after he raised concerns about possible executive branch defiance of court orders. The episode became another major flashpoint over judicial independence and political pressure on judges.
Do you think the Supreme Court is a death panel?
In the context of the cases that, not for free speech, no, that was not the context of that particular
Oh my goodness, okay. Well, it appears that you see the Supreme Court as a death panel, and that is some of the same rhetoric that unfortunately we continue to hear from some on the left who are trying to villainize justices who are doing their job. And I would like to just ask you, knowing that you have put this out, that the Supreme Court is a death panel, then let me ask you this. Do you look at Justices Sotomayor, Kagan, Jackson as members of the death panel, or is this just the justices that you disagree with?
I do not believe that the comments that you are referring to have relevance for this particular hearing, but here's what I will say. This is an administration that is threatening judges in addition to other people that he disagrees with. So, okay, yes, if your question is, do I defend judges? Am I worried about judges' security? I am. I am worried about this administration essentially threatening those judges.
I want to talk with you, Ms. Hemingway, about the State Department's use of the Global Engagement Center to censor news outlets like the Daily Wire and the Federalist. I know that this is something that you have had to deal with. And Daily Wire is located in Tennessee. We're proud of them. We are delighted that they chose to move from California over to Tennessee. And it is my understanding that the Global Engagement Center was created to counter messaging from bad actors, including terrorist groups, but the Biden administration weaponized it to silence conservative groups. And what has the censorship, I call it the censorship industrial complex, what do you think they're trying to hide when it targets outlets like the Federalist and the Daily Wire?
Thank you, Senator Blackburn. Yes, our reporter, Margot Cleveland, who's our senior legal writer, uncovered through her reporting facets of the censorship industrial complex and learned that the State Department was one of the federal entities that was engaging with non-governmental organizations and other entities in big tech to market, promote censorship tools and blacklists, which were then used against my publication, The Federalist, and also the Daily Wire. Publications that are a threat to the reigning orthodoxies are targeted by the censorship industrial complex. They want to exist without people pointing out their lies or the fact that there are really important debates. And so we are suing the State Department for that, and it is ongoing, this support of the censorship industrial complex.
On April 16, 2025, Secretary Marco Rubio announced the closure of the State Department office that had replaced the Global Engagement Center. The Daily Wire and the Federalist lawsuit then remained active until the Justice Department reached a settlement in April 2026.
It is the bureaucracy, really, which perpetuates this even more than a particular administration.
Yes, and I think it's so important to note that robust, respectful, bipartisan debate adds to our freedom, helps to keep us free, and allows that debate in the public square. And when you have an entity that becomes weaponized and shuts down one side of that speech and only allows speech with which it completely agrees, that is when you have that censorship writ large.
On April 1st, 2026, the State Department reached a settlement with the Daily Wire, the Federalist, and Texas over allegations involving the Biden-era Global Engagement Center. The agreement bars the State Department from funding or supporting technology designed to suppress Americans' protected speech and establishes long-term compliance monitoring. The Justice Department separately announced on April 10th that it had settled litigation challenging the State Department's alleged role in online speech suppression through the now-closed GEC. The developments went beyond the original hearing allegations. In September 2025, the State Department announced that it was dismantling the remaining functions of the former GEC after Congress had allowed its funding to expire in late 2024. Then, during the 2026 litigation, documents produced in discovery became part of the dispute over whether government-supported censorship technology had been used against domestic media. A federal court had previously allowed the Daily Wire, the Federalist, and Texas to proceed with significant parts of their lawsuit, finding that their complaints sufficiently alleged standing to challenge the government's conduct. That makes Senator Marsha Blackburn's questioning of Mary and Frank's much more relevant in hindsight. The hearing was supposed to examine the First Amendment and the so-called censorship industrial complex. The Senate Judiciary Subcommittee heard from witnesses representing very different perspectives, including Frank's Molly Hemingway of the Federalist, Jonathan Turley, Gabe Rotman, and Benjamin Weingarten. Blackburn immediately focused on Frank's past statement that the Supreme Court was a death panel. Her point was not simply to bring up an old social media post. She was questioning whether someone who had publicly used such strong language about the Supreme Court could fairly discuss constitutional protections and judicial independence. Franks tried to separate the comment from the subject of the hearing, arguing that her relevant expertise was the First Amendment. Blackburn wasn't satisfied. She wanted Franks to explain whether she believed the statement still reflected her view and whether it applied to justices she disagreed with or to the Supreme Court more broadly. That exchange illustrates one of the biggest problems in modern free speech debates. The credibility of the person making the argument can become almost as controversial as the argument itself. Frank's response was that the comment was not relevant to the specific First Amendment issues being discussed. Blackburn's response was essentially that the witness's previous public statements were relevant precisely because the hearing was about government power, constitutional rights, and the institutions responsible for protecting those rights. The discussion then moved to the Global Engagement Center. Blackburn argued that the GEC had been created to combat foreign propaganda and terrorist messaging, but was allegedly used in ways that affected American conservative media. Molly Hemingway supported that argument, describing what she called a broader censorship network involving government agencies, nonprofits, and technology companies. There is an important distinction here. The existence of government efforts to counter foreign propaganda is not itself evidence of unconstitutional censorship. Governments have legitimate national security responsibilities, including combating foreign influence operations. The constitutional question is different, Did government officials cross the line from countering foreign threats into encouraging or facilitating the suppression of Americans' protected speech? That distinction became central to the subsequent litigation. The Daily Wire, the Federalist, and Texas alleged that the GEC supported technologies and organizations that could be used to identify, downgrade, or financially disadvantage domestic media. In a 2024 ruling, the federal district court rejected key arguments seeking dismissal of the case and concluded that the plaintiffs had sufficiently alleged standing to challenge the conduct. That does not mean every allegation in the lawsuit was automatically proven. It means the court determined that the plaintiffs had presented enough of a legal case for significant portions of the lawsuit to proceed. And that is why the developments in 2026 matter. The dispute eventually produced a settlement that imposed restrictions on future State Department activity and created monitoring requirements lasting years. Reuters reported that the agreement would prevent the department from funding or promoting technologies intended to suppress American speech and would remain in effect through 2036, subject to the terms of the consent decree. So Blackburn's broader concern about government involvement in online speech did not simply disappear after the hearing. At the same time, the issue should not be reduced to Republicans oppose censorship while Democrats support it. The constitutional principle is much broader than either political party. A government should be able to fight genuine foreign disinformation campaigns. But the government also cannot use private organizations or technology companies as a substitute for censorship that it could not constitutionally carry out itself. That is the key First Amendment question. If a federal agency tells Americans directly that they cannot publish something, the constitutional problem is obvious. But what happens if that same agency instead pressures a private company, funds an outside organization, or supplies information to a platform and encourages the platform to suppress certain viewpoints? That is where the line becomes much harder to identify and much more important to enforce. The later settlement demonstrates why Congress was right to investigate the issue, regardless of which administration was in power when the conduct occurred. There is another important lesson from Blackburn's exchange with Franks. Free speech has to protect unpopular opinions on both sides. A constitutional system cannot depend on whether government officials agree with the speech being protected. Conservative media should be protected when government officials dislike conservative arguments. Liberal media should receive exactly the same protection when a conservative administration dislikes liberal arguments. That is why the issue is bigger than the Daily Wire, the Federalist, the GEC, or any individual witness. The real question is whether Americans can trust the government to remain neutral when political speech becomes controversial. And there is a second question that follows from Blackburn's confrontation with Franks. Should witnesses who strongly criticize one side of the political spectrum be disqualified from participating in a constitutional debate? Probably not. People are entitled to strong political opinions. The more important test is whether they can distinguish their personal beliefs from the constitutional principles they are defending. That is ultimately what makes this hearing worth revisiting. The First Amendment does not protect speech because the government approves of it. It protects speech precisely because political disagreement is inevitable. The 2026 settlement and the continuing litigation provide a powerful reminder that government involvement in speech requires extraordinary scrutiny. If an administration believes certain information is dangerous or misleading, it can make its own case to the American people. What it should not be able to do is secretly turn government power, funding, or influence into a mechanism for determining which American voices are allowed to reach the public. So the debate is this: where should the line be drawn between the government's legitimate fight against foreign disinformation and unconstitutional government involvement in suppressing Americans' political speech, and should that same standard apply regardless of which party controls the White House?